Hello and welcome to Williams Mullen Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host, Ed White, and today I'll be joined by my colleague, Courtney Reigel, who is an associate in our intellectual property practice group here at Williams Mullen, and we'll be discussing trending issues related to the NCAA's name, image, and likeness policy in 2023. Courtney, how are you doing today?
Thanks, Ed. I'm doing well and looking forward to giving listeners an update on NIL. How about yourself?
I'm doing well as well, and I am looking forward to this. I know we have a number of NIL podcasts that are already out there, so this will be, part of our effort and a continuance of updates for our clients and people who are interested in the NIL rules. So I just offer and invite them to listen to some of those other podcasts as well as they go through this update. So with that, tell us a little bit about how the NCAA is enforcing the policy and if there are any infractions.
Sure. So since our podcast last fall, where we discussed the state of NIL a year after the initial NIL policy went into place, there really hasn't been much in terms of NCAA enforcement of the NIL rules and guidelines. However, recent actions by the NCAA do signal a more aggressive approach to enforcement. The first thing I wanted to mention is the recent changes to the NCAA bylaws. So the NCAA amended its bylaws last October. The changes went into effect at the beginning of 2023. And these changes include a new presumption as well as a new evidentiary standard for NIL cases subject to NCAA regulation. I'm going to go ahead and quote some language directly from the bylaws. In cases involving NIL offers, agreements, or activities subject to NCAA regulation, the infractions process shall, quote, presume a violation occurred if circumstantial information suggests that one or more parties engaged in impermissible conduct. The enforcement staff may make a formal allegation based on the presumption. The hearing panel shall conclude a violation occurred unless the institution or involved individual clearly demonstrates with credible and sufficient information that all communications and conduct surrounding the name, image, and likeness activity complied with NCAA legislation, end quote. So this alters the balance of NIL investigations. Based on just circumstantial evidence, the NCAA has a presumption that a violation has occurred, but the school or individual then must clearly demonstrate with credible and sufficient information that the violation has not occurred, which is obviously a higher burden. So this will likely lead to more aggressive enforcement on behalf of the NCAA. The second topic relating to enforcement that I wanted to mention is the public negotiated resolution between the NCAA and the University of Miami. The NCAA released a press release on February 24th that the University of Miami's women's basketball team's coaches facilitated impermissible contact between two prospects and a booster. Essentially, what occurred is that Miami's head coach met a booster at a university fundraising event. She didn't know the booster at the time personally, but she did know that the booster was involved with NIL deals and student athletes at the school. At the event, the booster and Miami's coach discussed some upcoming visits for prospects. Miami's coach later called the booster to learn more about his work. And during this call, the booster mentioned that those prospects had actually initially declined a meeting with the booster during their upcoming visit. Miami's head coach then asked an assistant coach to contact the prospects and essentially let them know that the booster was a legitimate businessman and that the prospects then agreed to meet with the booster as a result of the assistant coach's call. At this point, there was some back and forth between the coaches and the booster to facilitate the meeting with prospects. And ultimately, the prospects ended up having dinner at the booster's home. During the visit, the parties allegedly did not discuss NIL opportunities, but the booster did kind of promote the University of Miami and the basketball program by talking about his children's experience at the school as student athletes. So the NCAA investigated this contact, and their investigation revealed that the activities did not actually impact the prospects' decisions of what schools to choose. Nonetheless, the NCAA and the University of Miami reached an agreement that the women's basketball team had violated NCAA recruiting rules based on the coach's involvement in arranging contact between the prospects and the booster. Boosters are not authorized recruiters, and they cannot have in-person, off-campus contact with prospects. So when the prospects visited the booster's home and when he provided them with meals, it violated recruiting and inducement rules. This investigation resulted in several penalties, including a suspension of the women's basketball team's head coach. And the resolution issued after the investigation notes that this particular investigation actually commenced back in 2022, prior to those changes in the bylaws that I just mentioned. And so moving forward, penalties may be harsher if the NCAA can presume a violation occurred. The resolution also went on to caution that boosters have become too involved with recruits and student athletes. The NCAA also sent a notice in February to member schools reminding them that the NCAA prohibits a school from compensating athletes for their NIL rights, and that this prohibition extends to entities acting on behalf of the institution. This language is thought to directly address schools like Texas A&M's recent announcement that they will be launching NIL initiatives through their own fundraising foundations. Finally, on enforcement trends, I just wanted to mention that the NCAA welcomed a new president, Charlie Baker, on March 1st, who has signaled that NIL enforcement will be a priority. Baker has also advocated for a federal law, stating that he wants to end the confusion that's occurring with the numerous state laws by having Congress address this and have one national standard for NIL deals. So with some background on what has been going on with NIL enforcement and the NCAA, Ed, what trends are we seeing with NIL deals themselves?
Yeah, thanks, Courtney. It's very clear from the enforcement that you just pointed out that, obviously NIL programs need to be taken seriously by athletes, by collectives, et cetera. And it will be interesting to see if former Governor Baker of Massachusetts will be able to get that federal law in place. But, certainly with regard to trends that we're seeing, I think a lot of debate can go on as to what NIL means to collegiate sports at the end of the day. But I don't think there's really any debate at this point that NIL has really taken off with regard to student athletes. During 2022, for example, about 20% of student athletes at Division I institutions participated in NIL activities. And according to the NCAA, 58% of those Division I student athletes receive some athletic aid. The majority of the student athletes receive partial scholarships, not full scholarships. So athletes are most definitely looking to use NIL dollars to supplement their scholarships. Open Doors is a great source of data online with regard to NIL activities. And according to Open Doors, the NIL industry accounted for $917 million in 2022. And it's estimated that NIL may account for up to $1.14 billion in 23. So it clearly is just continuing to grow. As you might imagine, NIL compensation at the Division I level leads the way. And there's approximately $3,195 per athlete this past year, accounting for NIL deals. But keep in mind that those numbers can be skewed because there are a few athletes at the top of the spectrum who have very large NIL deals. But nevertheless, that average is over $3,000 per athlete. Not surprisingly, the top earners usually come from FBS conferences. The Power 5 compensation could reach $16,000, over $16,000 per athlete this year. And the Group of 5 compensation could reach almost $6,000, $5,500 per athlete in the coming year. But NIL is not only confined to Division I. In the first year of the NIL policies, athletes at the Division II level averaged about $204 each. And athletes at the Division III level averaged $309 each. And this is through this past spring. So clearly, NIL dollars are funneling through to D1, D2, and D3 athletes. As far as what's projected for this year, Division II should see, or estimated they'll see $35.5 million in NIL compensation. That's an average of $338 per athlete. And Division III will see $58.5 million, or about $362 per athlete. So again, it's a big game. There's lots of dollars flowing, and these student athletes are able to take advantage of those dollars. But at the end of the day, where does that money come from? So let's take a little bit of a dive on that. Social media represents nearly 3/4 of NIL activity. And the kinds of social media activities can be segmented typically into 3 types. First, there's the social media influencers, where a brand pays a student athlete to post content about a particular brand. Second, there are student athletes' use of social media to promote their own brand or merchandise. And then third, there's the use of social media to sell content directly to consumers. Other popular NIL activities have been endorsements, appearances, instruction. So for example, maybe an athlete goes to a camp or a clinic, or even provides private instruction to other athletes. There's also student athlete merchandise sales. So for example, that Boston College shirt with the name of a particular athlete on the back. And not surprisingly, apparel and footwear account for about 20% of all NIL activity. And the rest, not surprisingly, are things like restaurants, fast food venues, which account for about 14% of NIL activity. And other NIL activity relates to auto sales, deals, financial services, and health services. So it really can be all over the map. But again, athletic wear tends to be at the top of the spectrum. So for our clients listening, what are some legal takeaways that they should be thinking about as they enter the NIL game? Well, first, you probably want to make sure that if you are looking at using social media in the NIL realm, you want to ensure that you have properly drafted influencer agreements that both protect and expand your brand and really lay out the rules of the road for how the influencer will utilize your brand under the NIL umbrella. You also want to ensure that you and your influencer comply with social media terms of use. You may be paying an influencer to post, for example, on various social media platforms. You certainly don't want to run afoul of those social media platforms' terms. And then finally, you should ensure that you have fulsome and complete endorsement agreements. If influencer is endorsing a particular product, you certainly want to make sure that you understand and that they understand how they should endorse that product. And again, the rules of the road in endorsing that product. And then finally, for collectives, other than social media, collectives certainly seem to be in the strongest position with regard to NIL participation. Open Doors found that 35% of all compensation comes from donors and the rise of NIL collectives. When we last discussed NIL collectives, I think it was this past fall in one of our podcasts, collectives were expanding beyond 100. So there were just over 100 collectives. Less than 1 year later, now there are over 200. So you can see the rise of collectives is only continuing to grow. They're proliferating. And so schools need to adjust to this reality and embrace collectives if they wish to use NIL to induce the best recruits and athletes to attend their schools. The most common collectives that are out there, and the ones that I think are most welcome at universities and colleges, appear to be nonprofits. And those are typically collectives that offer service opportunities to athletes. So, legal takeaways for collectives. If you are thinking of forming a collective for a particular university, you need to ensure that you're carefully considering the type of collective you wish to pursue. What will your mission be? Does it align with the university? Does it align with the athlete? You also want to make sure that your collective is properly organized and can legally operate under federal and state corporate laws. If it's a 501c3, it needs to be organized correctly, and you need to make sure that you have the bylaws and regulations and policies in place within your collective to make sure that it operates smoothly. And then finally, you want to ensure that your collective and its mission complies with the NCAA's NIL policy and individual school NIL rules. And if the law should change in the future, as we discussed earlier, and there should be a federal body of law, obviously collectives are going to need to make sure that they are complying with that federal law. And so, Courtney, just as we're talking about trends, I guess I'd be remiss if I didn't say one word about the transfer portal. Again, this is a debatable thing. People can think the transfer portal is a good thing. People can think the transfer portal is a bad thing. But at the end of the day, NCAA athletes are increasingly entering the transfer portal to explore playing for other schools. And, part of their decision is certainly playing time, where they lie on the depth chart, et cetera. But certainly they're also looking potentially for those NIL compensation dollars. And so when they enter the portal, that is part of the decision, which really brings us to a crucial issue that schools and collectives should consider. The NCAA is expressly clear that schools and collectives should not provide improper inducements or extra benefits to student athletes, including those athletes that may be considering the transfer portal. So schools and collectives must be hyper-focused to ensure that coaches and collectives do not induce student athletes to enter the portal based on representations of NIL deals or NIL compensation. Any such conduct certainly will invite an NCAA tampering charge, and we're already seeing that, obviously, with what you discussed earlier with regard to the NCAA violations. So with that, Courtney, let me just turn it back to you for any last thoughts you have on recruiting, et cetera, and we'll move on.
Yeah, thanks, Ed. I think your point on the transfer portal segues into a final topic we wanted to just briefly mention about how NIL is impacting high school recruiting. And that's because as we're seeing more college athletes enter the transfer portal, in part trying to get these NIL deals, that schools are then considering these already experienced athletes, sometimes over high school students, in a way that wasn't happening before NIL. This is forcing colleges to place more attention on the NIL deals, these collectives and athletes who have entered the transfer portal versus being able to just funnel all of their resources into high school recruiting. This also relates back then to the idea that NIL really is not intended to be a pay-for-play regime. Like with the transfer portal, schools and collectives have to be careful with how they are recruiting high school students, while NIL deals shouldn't necessarily be a part of the high school recruiting discussion. It's obviously going to be implicit in the process of getting top athletes to your school. That will wrap our discussion on trending issues related to the NCAA's name, image, and likeness policy in 2023. I'd like to thank Ed for joining me today on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast and other legal alerts. Please be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening, and until next time.